MRL3701, Hockly's Insolvency Law, Chapter 26, Cross-Border Insolvency. Number 26.1, Definition of Cross-Border Insolvency. Cross-border insolvency deals with a sequestration or a winding up involving property or debts in a jurisdiction other than the one in which the relevant court order is granted. In cross-border insolvency, therefore, the law of insolvency and winding up intersects with the conflict of laws. That would be private international law. Number 26.2. Main problems of cross-border insolvency. The main problems presented by cross-border insolvency include the following. See, for example, Hakan-Freeman, the Ancestral Model Law on Cross-Border Insolvency, an introduction in Ancestral Instruments in Southern Africa, 1999, Rand Afrikaans University 2-3. Number 1. The globalization of international businesses. People and assets can now move around the world more quickly than before. Representatives such as trustees and liquidators find it difficult to keep up with currency movements by clever debtors using modern technology. Number 2. Limitations on state power. Each state can dispose only of the debtor's effects and affairs in its own territory, but making the best use of multinational debtors' assets in business rescue attempts is less successful if impeding by state boundaries. Number 3. Lack of international instruments for dealing with cross-border insolvency law. Few international instruments, for example, treaties or conventions, exist. Those that do are not wide enough to cover all countries. Number 4. Conflict between the Universalist and Territorialist approaches to cross-border insolvency law. The Universalist approach would see all the debtor's assets and affairs being dealt with in one proceeding to which the courts and lawyers of other countries would give their assistance. The Territorialist approach, by contrast, confines the effects of the debtor's insolvency to the jurisdictional limits of each country in which there are assets and debts. Most legal systems blend the Universalist and the Territorialist approaches. Some countries are more in favor of the Universalist approach than others. Number 5. Equal treatment of similar classes of creditors. The principle that creditors in the same class should in principle be treated equally is a good reason not to discriminate against foreign creditors. Nevertheless, in territorialist fashion, each legal system preserves some protection for local creditors before foreign representatives, such as trustees or liquidators, will be allowed to take local assets or their proceeds out of the relevant jurisdiction and back to the foreign proceedings for distribution. There being no international convention as such to deal with the problems outlined above, the United Nations Commission on International Trade Law, UNCITRAL, has proposed a model law on cross-border insolvency in 1997, suggesting how matters such as access by foreign representatives and creditors, recognition of such persons and foreign proceedings, and cooperation between courts and practitioners should be dealt with by each state in its insolvency laws. This model law is not a treaty but a template which individual states are free to adopt and adapt. At present, the South African law on cross-border insolvency law is controlled by common law principles, but the legislature has enacted a South African version of the Ancestral Model Law. This statute, the Cross-Border Insolvency Act No. 42 of 2000, with a commencement date of the 28th of November in 2003, will come into effect only once the Minister of Justice has designated the foreign countries to which the Act will apply. See, for example, Section 2, Subsections 2 to 5. Number 26.3. South African Common Law of Cross-Border Insolvency. Whether the foreign representative, such as the trustee or liquidator, may deal with South African assets is a question determined by a division of types of property and the classification of persons. Movable property is governed by the law of the natural person's domicile, the lex domicili. The debtor declared insolvent by the court of his domicile is thus, by affection, automatically divested of his movables throughout the world and therefore in South Africa. The foreign representative is still prudent in seeking recognition from the South African courts before dealing with local assets. The representative of a debtor that is a juristic person is obliged to seek such recognition. He must show that he was appointed where the company is registered or has its principal place of business, and that his claim is genuine. Whether it is valid is a decision not for this court, but in proceedings that he may bring after he has been recognized. Immovable property is governed by the law of the place where the immovable property is situated, the lex situs, whether the debtor is an individual or a juristic person. The South African courts apply comity, convenience, and equity in exercising their discretion to recognize the foreign representative. Comity is not applied, though, if it conflicts with public policy. South African creditors are protected by conditions in the relevant court order providing for the realization of the assets and the payment of local creditors' claims before those assets or their proceeds may be removed to the foreign jurisdiction. Recognition of the foreign representative enables him to rely on domestic South African law in carrying out his duties. An external company registered as such in South Africa may be wound up as though independent of its related foreign company, even if the latter continues and the opposite also applies. The company may thus be subject to simultaneous concurrent winding up processes, and the discontinuation of foreign winding up processes cannot in itself affect South African process. The respective liquidators can deal independently with assets and liabilities of the company in various countries. The Supreme Court of Appeal in Proudfoot's case, that is, Saxteen NO versus Proudfoot SA Proprietary Limited 2003, did not explore the implications of the concurrence of separate proceedings regarding a single entity. However, Olivier holding that the registration in the Republic of South Africa of an external company does not result in there being two separate legal personae, registered respectively in two countries. There is only one legal persona, registered in two countries. The consequence of this situation can obviously lead to seemingly irreconcilable conflicts of authority and powers between two simultaneous and concurrent liquidators, and hence to difficult legal and commercial problems. In cases of dual registration, a principle of demarcation in the event of a dispute between the liquidators will have to be developed. It follows that an external company retains its separate legal personality, their persona, even after being deregistered in South Africa. The South African liquidator may act under Section 391 of the 1973 Act to impeach voidable transactions in South Africa, regardless of where the relevant property is situated. If that property is situated outside South Africa, the liquidator must then seek recognition of the South African court order in the appropriate foreign country. The liquidator may thus choose whether to act under Section 391 of the Companies Act or to seek foreign recognition of his appointment with a view to pursuing impeachment and recovery processes outside South Africa. The court quo, applying the principle that the company in these circumstances remains a single entity, nevertheless held that the separate winding up proceedings in two different countries can only relate to separate, non-identical estates of that company, each having its own assets and liabilities. The status of a company in private international law is determined by the law of its country of incorporation. Section 340 of the Companies Act governs companies unable to pay their debts at the institution of the impeachment proceedings. In Proudfoot's case, the parent company in the Namibian winding up, which was subsequently rescued in the Namibian Compromise, was no longer a company unable to pay its debts in Namibia, and that compromise bound all creditors of the Namibian estate of the company. The subsequent action by the South African liquidator of the South African external company in winding up to impeach as voidable disposition certain payments received in South Africa by a South African creditor of the parent company, this failed. In a further appeal in the South African liquidator's impeachment action, the Supreme Court of Appeal decided the matter not on the basis of cross-border insolvency law, but of the interpretation of Section 340, Subsection 1 of the Companies Act, read together with Sections 29, Subsection 1 and 30 of the Insolvency Act 24 of 1936. It was held that this action was instituted after the compromise was sanctioned and the compromise had a considerable impact on the insolvency of the company. The liquidator had not proved that the debtor company was unable to pay its debts at the institution of his action. The order by the court a quo was therefore amended to one of absolution from the instance. It is suggested that a principle of demarcation is required when a dispute between the respective liquidators of a company incorporated in one state and registered as an external company in another state has to be settled on the basis of cross-border insolvency. Such a principle should acknowledge that the company, though remaining a single person, has separate estates in separate states. If a South African representative, such as a trustee or liquidator, seeks to pursue investigation and recovery processes outside South Africa, he may have to apply to the South African High Court for letters of request, recognizing his appointment as a preparatory step for approaching the relevant foreign authorities. In seeking these letters of request, the representative need only hold the genuine belief that foreign proceedings should be initiated. He is not required to establish a prima facie case or prove a reasonable prospect of success in uncovering assets through foreign examination, in order to convince the South African court to grant him letters of request. It does not matter whether the representative, in taking this decision, which is his alone to take, relies on impeccable information or merely hearsay. Number 26.4. Cross-Border Insolvency Act. The Cross-Border Insolvency Act includes chapters on interpretation and fundamental principles, access of foreign representatives and creditors to South African courts, recognition of foreign proceedings and relief, cooperation with foreign courts and foreign representatives, and concurrent proceedings. The Act aims at cooperation between South African courts and foreign courts in cross-border insolvency matters. Improved legal certainty for trade and investment, good administration to protect creditors and their interested persons, including the debtor, protection of the assets and the maximization of their value, and assistance in business rescues, this protecting investment and saving jobs. That is in the preamble. The Act applies where a foreign court or representative asks South Africa for assistance in foreign proceedings, or conversely, where such help is requested in a foreign court in proceedings under the laws of the Republic relating to insolvency. It also applies where foreign proceedings and South African insolvency proceedings run concurrently as regards the same debtor, or where creditors or other interested foreigners ask to begin or to take part in South African insolvency proceedings. This is in Section 2, Subsection 1. By a South African deviation from the ancestral model law, however, the Cross-Border Insolvency Act then limits its operation in terms of Section 2, Subsection 1 to certain designated states in terms of Section 2, Subsection 2 to 5. The Act applies in respect of any state designated by the Minister of Justice by notice in the Government Gazette. Before designating such a foreign state, the Minister must be satisfied that the recognition accorded by the law of that state to proceedings under the South African Insolvency Law justifies the application of the Cross-Border Insolvency Act to foreign proceedings in that state. The Minister may, by notice in the Gazette, withdraw any such notice, though this withdrawal does not affect pending legal proceedings, which thus continue as if the notice had not been withdrawn, in terms of Section 2, Subsection 5. All notices must be approved by Parliament before they are published, so although the Act was assented to on the 8th of December 2000, it will not take effect until the Minister designates the relevant states. The Act yields to a treaty or other agreement concluded by South Africa and conflicting with the terms of the Act in terms of Section 3. The High Court recognizes foreign proceedings and cooperates with foreign courts in terms of Section 4, and a South African representative such as a trustee, liquidator or judicial manager may act in a foreign state for South African insolvency proceedings, as allowed by the relevant foreign law in terms of Section 5. Section 5 should now be read as referring to the business rescue practitioner in terms of Section or Chapter 6 of the Companies Act No. 71 of 2008. The court may refuse to carry out an action falling under this Act if this would conflict with South African public policy in terms of Section 6. The Act is to be interpreted against its international background and with a view to inform application and the upholding of good faith in terms of Section 8. As regards foreigners' access to South African courts, the foreign representative may apply directly to our courts in terms of Section 9, and in doing so does not automatically subject himself to the debtor's matters to that jurisdiction for other purposes in terms of Section 10. He may seek to begin insolvency proceedings here if the South African requirements for doing so are not met in terms of Section 11. Once recognized, he may take part in South African proceedings in terms of Section 12. Foreign creditors enjoy the same rights as their South African counterparts, although the South African ranking of claims applies. Foreign creditors' claims do not rank lower than non-preferent claims, in terms of Section 13, Subsection 1 to 2. Those creditors are entitled to notification as creditors, in terms of Section 14. The foreign representative may seek the High Court's recognition of the foreign proceedings in which he has been appointed. The relevant documentary confirmation must be supplied, including a statement of all foreign proceedings that he knows relate to the debtor, in terms of Section 15. The debtor's registered office or habitual residence is rebuttably presumed to be the center of its or his main interests, in terms of Section 16, Subsection 3. Subject to the public policy exception, the foreign proceedings, if they meet the Section 1, Subsection G definition, and the foreign representatives meets the Section 1, Subsection H definition, must be recognized once the documentary requirements in terms of Section 15 have been fulfilled and the application is made to the High Court, in terms of Section 17. The foreign proceedings must be recognized either as foreign main proceedings in the state where the debtor has the center of its main interests, or otherwise as foreign non-main proceedings if the debtor has an establishment in the foreign state. An establishment is any place of operations where the debtor carries out a non-transitory economic activity with human means and goods or services, in terms of Section 1, Subsection C. Pending the recognition decision, the High Court may, at the foreign representative's request, grant urgent provisional relief to protect the debtor's assets or the creditor's interests. This relief would include a stay of execution, the entrusting of perishables, depreciating, or endangered assets to the representative or another court designee for preservation or realization, suspension of the debtor's right to dispose of his assets, the examination of witnesses and the collection of evidence, or any other appropriate relief available under South African law, in terms of Section 19, Subsection 1. Relief may be refused if it would hinder the foreign main proceedings, in terms of Section 19, Subsection 4. The recognition of foreign main proceedings stays the commencement or the continuation of individual proceedings in connection with the debtor's affairs, as well as execution against assets, and suspends the debtor's right to dispose of assets in terms of Section 20, Subsection 1. The ambit of this stay and suspension is controlled by Sections 20, 23, and 75 of the South African Insolvency Act, and Sections 341 and 359 of the South African Companies Act No. 61 of 1973, in terms of Section 20, Subsection 2 of the Cross-Border Insolvency Act. Despite the stay, it remains competent to begin proceedings for preserving a claim against the debtor, to request the opening of South African insolvency proceedings, or to file claims in those proceedings, in terms of Section 20, subsection 3 to 4. In addition, the recognition of foreign proceedings as foreign main proceedings renders Section 21 of the South African Insolvency Act applicable to assets situated in South Africa to the same extent as if the debtor had been sequestrated by a court, in terms of Section 20, subsection 1d. The court may grant various forms of relief after recognizing foreign proceedings, whether main proceedings for non-main proceedings, in terms of Section 21. The court may thus stay proceedings and execution, suspend the debtor's rights of disposition, allow examination of witnesses and the collection of evidence, entrust the administration or realization of assets to the foreign representative or a designee, extend urgent provisional relief granted under Section 19, subsection 1, and grant any additional relief that would be available to a trustee, liquidator, judicial manager, curator of an institution, or receiver under South African law. At the foreign representative's request, the court may even permit the distribution of the debtor's South African assets, if it is sure that the South African creditors are protected, in terms of Section 21, subsection 2. For foreign non-main proceedings, the court has to be sure that the relief concerns assets that, under South African law, should be dealt with in such proceedings, or concerns information needed there, in terms of Section 21, subsection 3. The court is obliged, when granting relief under Section 19 or 21, to ensure that adequate protection is accorded to creditors and others, including the debtor. It may set conditions for such relief and alter or amend it, either at the request of the foreign representative or a person affected thereby, or its own initiative, in terms of Section 22. The foreign representative may rely on South African impeachment provisions, in terms of Section 23. If he is acting in foreign non-main proceedings, however, the High Court has to be sure that the legal action concerns relevant assets, in terms of Section 23, subsection 2. The representative may also intervene in proceedings to which the debtor is a party, in terms of Section 24. In the proceedings mentioned in Section 2, subsection 1, the court shall cooperate to the maximum extent possible with foreign courts or foreign representatives, either directly or through a trustee, liquidator, judicial manager, curator, or receiver, in terms of Section 25, subsection 1. And the court may communicate and seek information or help directly from foreign courts or representatives, in terms of Section 25, subsection 2. With the High Court supervision, similar cooperation is expected of a South African representative, who in turn has the right of direct communication with foreign courts and representatives, in terms of Section 26. Examples of cooperation include the appointment of a person to follow the court's directions, communication of information, coordination of the administration of the debtor's affairs, judicial approval and carrying out of agreements about the coordination of proceedings, and the coordination of concurrent proceedings against the same debtor, in terms of Section 27. As regards concurrent proceedings, it is provided that once foreign main proceedings have been recognized by the High Court, it is possible to launch South African insolvency proceedings only if the debtor has assets in South Africa, in terms of Section 28, subsection 1. The effects of the South African proceedings are then limited to those assets and to any others which, so as to coordinate proceedings in terms of Sections 25 to 27, should be administered in those proceedings, in terms of Section 28, subsection 2. If foreign proceedings and South African proceedings concerning the same debtor are running concurrently, the High Court must seek cooperation and coordination under Sections 25 to 27, in terms of Section 29. Further rules are supplied that depend on the timing of the respective proceedings, in terms of Section 29, subsection A to C. If several foreign proceedings are in progress, the High Court must seek cooperation and coordination under Sections 25 to 27, in terms of Section 30. Provisions is made for any relief already granted in foreign non-main proceedings to conform with foreign main proceedings that are later recognized in terms of Section 30. Once the foreign main proceedings are recognized by the High Court, the debtor is rebuttably presumed to be insolvent for the purposes of institution of South African proceedings, in terms of Section 31. In general, a creditor who has been paid part of its claim in foreign insolvency proceedings is not entitled to be paid for the same claim in South African insolvency proceedings regarding the same debtor, so long as other creditors of the same class are paid proportionately less than the payment that that creditor has already received, in terms of Section 32. The Hodgepodge rule this applies. And then number 26.5, the conclusion. The Cross-Border Insolvency Act, when it comes into force in the international system for cooperation intended by the model law, will provide a gateway for foreign representatives to gain access to South African proceedings and for South African representatives to gain access to foreign proceedings. The Act, though limited by the designation requirements in Section 2, subsections 2 to 5, does enable South African courts and practitioners to play a positive role in cooperating with their foreign counterparts, particularly in attempting business rescues. Once the foreign representatives have gained access to the South African legal system via the Cross-Border Insolvency Act, however, they will have to abide by the relevant South African rules, substantive and procedural.